Good morning. This is Stephen Lewis. I'm going to jump right into this today. My topic today is from public accommodations to open housing, debating the Civil Rights Acts of 1964 and 1968. When President Kennedy proposed his omnibus civil rights bill in June 1963, he framed racial discrimination as a moral issue as old as the scriptures. Religious leaders testifying before Congress agreed condemning segregation as blasphemy against God, yet the debate that followed exposed how contested the moral terrain truly was. Opponents of the bill inverted its ethical logic entirely, insisting that those who sought to compel private businesses to serve all customers were themselves the bigots, coercing individual conscience, trampling property rights, and substituting federal mandate for the freedom of association. Some senators drew on a theology of segregation, arguing that racial separation was divinely ordained. As Lyndon McLean has shown, the 1964 debate was as much a battle over the meaning of bigotry and moral authority as it was a fight over statutory text. The legislative outcome reflected these conflicts. Liberal Democrats wanted an equal employment opportunity commission modeled on the National Labor Relations Board, with cease and desist powers to investigate and remedy workplace discrimination. Conservative Republicans, fearing a partisan administrative apparatus with sweeping authority over the private economy, refused. Dirksen's compromise was decisive. The EEOC would have no enforcement power of its own. Instead, aggrieved individuals would bear the burden of filing suit in federal court with attorneys' fees shifting to incentivize private litigation. As Sean Farhang has documented, this outcome was not a legislative accident, but a conscious, explicit rejection of administrative enforcement, a structural choice that would define civil rights law for decades. The 1964 Act was almost immediately recognized as incomplete. Title II desegregated lunch counters and waiting rooms. Title VII attacked employment discrimination, but housing, arguably the most consequential arena of racial inequality, was left untouched. Brown Nagin's examination of Atlanta illustrates how even partial victories mattered. Civil rights lawyers used the new act as leverage to desegregate Grady Hospital, demonstrating that federal law could transform entrenched institutional practices, yet the unfinished agenda was unmistakable. By the mid 1960s, the U.S. Commission on Civil Rights had identified housing as the most ubiquitous, deeply rooted civil rights problem in the nation. Johnson pushed hard for open housing legislation beginning in 1966, but the bill died twice, killed by a combination of white suburban backlash, summer urban riots, and Vietnam era congressional fatigue. The politics shifted catastrophically in April of 1968 when King was assassinated in Memphis. Johnson moved with urgency, casting the Fair Housing Act as the most fitting memorial to King's life. Stephen Goldswig has described this as the rhetoric of transcendence. Johnson transformed national grief into political obligation, arguing that passing fair housing legislation was the one concrete act that could deny violence its victory. The House concurred within days of the Senate vote. The structural parallel between the two acts is striking, as Farhang has demonstrated. The story of the Fair Housing Act replays the story of Title VII with remarkably similar dynamics. Dirksen once again played the pivotal role, introducing a compromise that stripped administrative enforcement from the bill in exchange for Republican votes to close the filibuster. He remarked from the Senate floor that he was in almost the identical position he had occupied in 1964. The Fair Housing Act passed weaker than its advocates had hoped, with enforcement provisions critics called impossibly weak and individual complainants left to navigate federal courts largely on their own. Together, the Civil Rights Act of 1964 and the Civil Rights Act of 1968 form a legislative dispatch, each shaped by the same political architecture, each propelled by national crisis, and each marked by the same tension between moral ambition and the institutional compromise. The debates they generated over federal power, moral authority, and the capacity of law to transform social reality have never been fully resolved.